Hi, it's Emily from Apex Law Prep. I'm back. I got some requests to do question 3 from the February 2023 California bar exam, so I thought we'd give it a shot. Let's jump in. Starting with the cause of the question, except this sentence right before is jumping out, so I'm going to start there. Tuan decided to sue for damages based on his rights under his lease with Leo. Okay, so damages tells me it's civil. And then under his lease with Leo tells me this is landlord tenant. And then the cause, what claims, if any, may Tuan reasonably assert against Leo? So tenant versus landlord, discuss. 2, what claims, if any, may Tuan reasonably assert against Annika? Discuss, don't know who that is. And then what counterclaims, if any, may Leo reasonably assert against Tuan? Discuss. So counterclaims, landlord versus tenant. Okay. Tuan sells antique furniture. Okay, he's a seller of antique furniture. I think he's a merchant. I don't know if that matters. He signed a 10-year lease for a warehouse owned by Leo at $1,000 a month with a start date of January 1st. Okay, he signed. That tells me statute of frauds is going to be satisfied if this thing is going to be enforced against him to the extent statute of frauds applies. The next thing, 10-year lease, tells me statute of frauds applies because this is an interest in real estate, right, in land that's greater than a year. And then it's for a warehouse. Warehouse tells me it's commercial, not residential, so that implied warranty of habitability will not apply. And then owned by Leo, the landlord, at $1,000 a month with a start date of January 1st. It's a 10-year lease, start date of January 1st. It's a term for years. So it's going to be a 10-year term. It's going to start on January 1st, presumably of this coming year. And then 10 years later, on December 31st, it's going to expire. Right? A term for years means that there's this fixed start date, an absolute end date. There's no notice required to terminate. You just automatically end it on the end date. Okay. The warehouse would be used to store Tuan's inventory. Okay, so he's not gonna like attempt to live there. We're not gonna have some sticky situation where maybe implied warranty compatibility applies. It's just used for commercial stuff. When Tuan attempted to occupy the warehouse on January 1st, start date of his lease, he discovered Annika, that's who Annika is, there pursuant to her validly executed lease, which was not due to end until January 31st. Oops, okay. So we have Leo, landlord, looks like he double rented the same property, the same warehouse to Annika, overlapping the end of her lease with the start date of Tuan's. What that makes me think about is we think about landlord's duties to a tenant. The first one I always think about is the duty to deliver the property. If you know it, there's this split between the English rule and the American rule. The English rule says he has a duty to deliver not just legal possession, right, the legal right to possess the property, but actual physical possession. The American rule says you just have to give them the legal right to possess, and if somebody else is there, as long as they're not there lawfully, not your problem, right, for the landlord. But here, Annika is there pursuant to her validly executed lease, so that's going to be a breach of both of those, right, American or English rule, because not only does he not get that physical right to possess it because Annika's there, which breaches that English duty, he also doesn't even have the legal right to possess it because she's there pursuant to her validly executed lease, right, and her lease presumably is first in time before Tuan's, so it has priority, meaning, right, you don't need to know all that, but the idea is she's lawfully allowed to be there. So this is a breach of that duty to deliver possession to Tuan under either the English or the American rule. Okay, Tuan then immediately rented another almost identical warehouse from Bruno on a month-to-month basis for $1,500 a month. Okay, he immediately rented it. This is making me think of mitigation. So he's essentially covering, the word we use in UCC, but he's mitigating. He's finding some replacement performance. Another almost identical warehouse from Bruno for $1,500 a month. So it's almost identical. So that makes me think that even though he was going to pay $1,000, he's paying $1,500. It's probably a reasonable amount to pay. It's almost identical. Okay. All right, well, if nothing else happens there, and we'll look, but this is a breach of that duty to deliver possession under that English rule or the American rule. His options are going to be he can terminate that lease or he can continue the lease but sue for damages for the amount of time that he's not able to possess this property. So I don't know which one he's going with here, but that's what I'm thinking about. Right? It doesn't look like he actually took steps to terminate. but we'll see. Okay. When Tuan returned to Leo's warehouse on February 1st, okay, so he's not terminating, he's still trying to have his lease. Okay. When he returned to Leo's warehouse on February 1st, Annika told Tuan she was not leaving, okay, until May 31st. Okay, Annika. So she is going to stay. Now, if this is without Leo's permission, this means she's a holdover tenant, right? So her lease ended January 31st. She's going to hang out for a few more months. That's not okay. Okay, what's going to happen? Let's see. When Tuan visited the warehouse on June 1st, okay, so after Annika saying she's finally going to be gone, he discovered that landlord Leo, had stored equipment in the warehouse that made 25% of the space unusable. Okay, so presumably Annika's finally gone, right? So while she was there from February, March, April, and May, when she wasn't supposed to be, right? She was this holdover tenant, assuming it was without Leo's permission. And then she is trespassing on Tuan's land because he has the right to possess it starting on, well, really January 1st, but for her purposes, starting February 1st. Okay. So now Leo is storing equipment in the warehouse that makes 25% of the space unusable. So Leo's doing two things here. One, he's trespassing, right? Because his stuff is like physically intruding on Tuan's space that Tuan has the right to possess, assuming there was nothing in the lease that allowed him to do this, which they didn't say that there was. And then the other thing that jumps out at me is the covenant of quiet enjoyment. So we think about these landlord duties. We talked about the right to deliver, right? I should say the duty to deliver the premises. Another landlord duty is that there is this implied covenant of quiet enjoyment in every lease, right? Unless they waive it, which again, no facts yet anyway that they have, there is this implied promise by the landlord that the landlord's not going to do anything that's going to disrupt the tenant's enjoyment of and right to the property. What can interrupt that? Actions by the landlord or the landlord's agent or somebody with superior title than the landlord that either actually can evict, like literally physically prevent the tenant from having possession, right? Actually evict him, or constructively evict him, meaning things are so disruptive that it's as if he was getting actually physically evicted. So this is 25% of the space is unusable. That looks to me like an actual eviction from just part of the property. So called partial actual eviction of 25% of the property, which is going to be a breach of that covenant of quiet enjoyment. Tuan refused to take possession and informed Leo that he was terminating his lease immediately. Okay, so remedies for breach of that covenant of quiet enjoyment. You can sue for damages if you want to remain in possession, or you can terminate, which is what it looks like it did. There's different remedies available if it's actual eviction or constructive. For constructive eviction, right, that's the one where they're not physically preventing you from being there, but they're basically making it so bad for you that you have to leave. Like, oh, this is so horrible, I can't stay. It's as if you're physically evicting me. For that one, you have to do some stuff, right? You have to give notice to the landlord and give them a reasonable time to fix it. And then if they don't meaningfully act to fix it, then you can leave and treat it as if they've evicted you, right? And then terminate. Here it's a physical actual eviction, partial. So he's allowed to terminate his lease. He could also stay if he wanted to, and then common law rule, he could withhold all his rent. More modernly, he could only abate, right? So prorate. So if 25% of his property is unusable, he would be able to reduce his rent payments by 25%. But that's not an issue here because he refused to take possession. And he says he's terminating his lease immediately. So he's allowed to terminate. One thing that, you don't need to know, but if you do know it, it says he informed Leo that he was terminating his lease. It doesn't say how he informed him. Did he put it in writing or was it oral? And this is June 1st. So this is like 6 months in, 5 months, whatever, into the lease. So there's still like 9.5 years left on this lease. So technically, I think that he should be giving this notice to terminate in writing for statute of frauds purposes. If informed means written, great, that's not an issue. If informed means oral, then I'm thinking that termination is not going to technically be proper, right? Even though he is allowed to terminate because of this partial actual eviction, not actually the proper means to do so. In which case the landlord could treat it as it would be, right, abandonment. And then the landlord would have these options of either accept it as surrender and be like, look, you're walking away, you're abandoning, but I'm going to treat that as letting you get out of your lease. That's surrender. Or he can ignore this, informed him that he's terminating. And be like, well, if you're abandoning because it's not proper termination, then I'm just going to ignore it and still keep charging you rent every month for the duration of your lease. Or he can retake possession of the property and relet it on the tenant's behalf, right? He can be like, look, you are wrongfully abandoning this property, right? Again, this is all assuming that this termination is improper if it's not written and it was required to be. Say you're wrongfully abandoning, I will be nice, I will do you a solid, and I will take possession of this property and attempt to relet it on your behalf, right? To reduce your damages. But if I can't relet it for the same amount of money, you are responsible for that difference in value. Okay, it's a lot, but those are just all the things that I'd be thinking about and then waiting to write until I get through to the end and see what's actually going to happen here. Okay, the next day, Leo retook possession of the warehouse and placed for rent signs in several windows. Okay, so he's not doing that ignore step. Okay, shortly after, Leo executed a 10-year lease with Juanita for the warehouse at a monthly rent of $500 with a start date of July 1st. Okay, so he's retaking possession. I would say from that we could imply that he is either this termination is proper, right? Because he informed him in writing, and it's fine, or he's accepting this abandonment. If it's improper termination, then it's just abandonment. He's accepting it as surrender. We can imply that by the fact that he's just retaking possession, and then he's just going to go ahead and find a new tenant. If instead we say he's retaking it, but maybe he's going to try to assert he's only retaking it and then going to try to release it, right? Relet it on Tuan's behalf, then we're in that third option, right? Where Tuan would still be liable for this difference in price. And this is a 10-year lease with Annika for $500 a month, and Tuan's lease was $1,000 a month. So under that rationale, Tuan would still be liable for that $500 a month. Okay. Tuan rented Bruno. We'll talk more about this when we actually answer the question. So I'm just brainstorming here. Tuan rented Bruno's warehouse from January to June. Okay, that's the one. Immediately rented. Okay, so this is the one that he rented initially in January when Annika was still there. He kept it till June, so that's the $1,500 a month. He later signed a new lease for 9.5 years, starting on July 1st with a monthly rent of $1,500. Presumably, I don't know, with Bruno or with somebody else. It doesn't say, but either way, it's $1,500 a month. Okay. And okay, next fact, Tuan has never paid any rent to Leo. Okay, why do I care about that? So at common law, the duties of the landlord and the duties of the tenant were independent, meaning no matter what the landlord did, Tuan was still responsible for paying rent. He could sue separately for landlord's breaches of his duties, but he still had to keep paying rent, and vice versa. Modernly, we say that the tenant's duty to pay rent is dependent on the landlord's upholding of his duties. Usually we say that landlord's duties are not dependent on tenants. So, right, even if Tuan hasn't paid rent, we're going to say, well, if landlord's duty to, deliver possession, and if his duty, of the implied covenant of quiet enjoyment is still independent, then landlord's still obligated to do that, and Tuan not paying wouldn't change it. But that's what that makes me think about, is I would raise that issue of dependent versus independent. Okay, Tuan decided to sue, we read this already, but to sue for damages based on his rights under his lease with Leo. Okay, so there's a lot going on here. Just take it one question at a time. Okay, so number one, what claims, if any, may Tuan reasonably assert against Leo? Okay, so Tuan versus Leo. So I'm thinking, based on what we talked about, duty to deliver, duty of this implied covenant of quiet enjoyment, I'm thinking that what I want to do here is kind of go act by act, like I would in a PR essay, because it's kind of confusing, right? It's like January 1st to 31st, there's this one thing happening with Annika, and then February to May, there's another thing, and then June 1st, there's this other thing with the 25% of the space unusable. So I'm going to break it up, and I'm just going to take it one act at a time, dividing it up in those 3 acts, because I think I think that's going to help me like place my rules better, and it's going to make this feel more manageable and less chaotic. Okay, so first, I'm going to say what claims can Tuan reasonably assert against Leo for just that January 1st to January 31st period where Annika was lawfully there. And for that, I'm going to talk about that duty to deliver possession. Again, English rule, actual and legal possession, American rule, just legal possession, both breached here. So under the English rule, this is breached because Tuan doesn't have either the legal right to possess, because Annika's there pursuant to his validly executed lease, or the actual right to possession, because Annika's there. Under the American rule, it's just because he doesn't have this legal right. And then my remedy for that, he could have terminated, but he's not, so it's damages. And that's going to be expectation damages, the difference between the $1,000 a month he expected to pay for a warehouse, and then the difference between that and the $1,500 a month he's actually paying for the almost identical warehouse. Again, I think that's reasonable mitigation because it's almost identical. So I'm going to say he's going to get $500 for the month of January under this breach of Leo's duty to deliver possession. Under either the American or the English rule. And I know the question just asks what claims Tuan can assert. I know they're not asking me specifically about remedies or how much he can recover in damages, but they've given me the numbers. So if I see it, I'm going to use them. So I'm going to say 500 for that breach of the duty to deliver possession for January. And then I'm going to move on from that to my next time period of February 1st to May 31st. And what I'm thinking about there is two things. I'm thinking first that duty to deliver possession. So under the English rule, still violated because Annika's still there, still no actual possession. And so for that, the damages is going to be from February through the end of May, that $500 a month. Again, could have terminated, but didn't. And then under the American rule, if I know this distinction, I'm going to point out, under the American rule, there's no longer a breach of the duty to deliver possession. Assuming Annika's a holdover tenant there, right, it looks like she no longer has the legal right to be there. Tuan now has the legal right to possession. So the fact that Annika's there is not a breach of the American rule, but it is a breach of the English rule. And then the other thing I'm thinking about is the covenant of quiet enjoyment. So insofar as Leo is failing to act, right? His failure to try to evict Annika, or, they don't say, maybe he's like taking rent payments from Annika and like holding her to this new like periodic tenancy and affirmatively like allowing her to stay. Either one of those acts by Leo, I'm going to say, is a breach of the covenant of quiet enjoyment, which her presence there and Leo's act of letting her be there is allowing it's allowing Tuan to be evicted, essentially, right? So it's actual eviction. And so I'm going to say that's a breach of the covenant of quiet enjoyment. And the damages for that, he could terminate, but he doesn't. So his damages for that are going to be the same as those damages under the breach of the duty to deliver, and that's going to be that $500 a month. Okay, so that's what I'm thinking about for this February through May period for Tuan versus Leo. And then I'm thinking I also want to use that Tuan has never paid any rent to Leo fact here to talk about the dependent versus independent covenants. So if Tuan and Leo's duties are independent, those covenants are independent of each other, then the fact that Tuan didn't pay rent does not excuse Leo from complying with the covenant of quiet enjoyment. If, on the other hand, these were dependent, and we say that we're in some jurisdiction that says landlord's duty to abide by the covenant of quiet enjoyment is dependent on tenant's duty to pay rent, then Leo's going to point to the fact that Tuan never paid any rent to be like, hey, look, I don't have to comply with the covenant of quiet enjoyment. So I would throw that in there if I see it. If not, no big deal. And that's what I would do for that time period. And then I'm going to move on and I'm going to talk about my third act by Leo, which is this on June 1st, making 25% of the space unusable because Leo has stored equipment in the warehouse. So I see two things there, which I already mentioned, trespass and covenant of quiet enjoyment for partial actual eviction. So the trespass piece, if you see it, great, throw it in. If not, don't worry. But he's trespassing, right? He's making 25% of the space unusable, presumably intentionally, physically intruding with his equipment, right? So it's this tangible invasion. The damages for that is going to be like the loss of use, and that's, he made 25% of the space. So had Tuan been paying rent this whole time, I'd say that his damages would be 25% of the rental value, but he never paid rent anyway. So not really any actual damages there. For trespass, you can also get nominals and then, punitives if it's like repetitive trespass conduct. I don't see that being an issue here. And then alternative to trespass, breach of covenant of quiet enjoyment for that partial actual eviction. So again, the remedies for that would be he could terminate, or he could remain in possession and collect damages. It looks like he terminated here. Whether that's proper, we sort of talked about already with, if he was supposed to put it in writing for the statute of fraud, then he just informed, and that means oral, then it's really just abandonment. Which I think I would save to talk about until we talk about Leo's counterclaims, because Leo could argue that he improperly abandoned. So I'm going to save that, but I would say that he, attempted to terminate. His other remedy would have been to remain in possession and either withhold completely his rent for common law, or modernly just reduce it by 25%, but he didn't do that. So. And then insofar as Tuan is going to try to claim damages for that 9.5 years for that difference in value for that rent that starts July 1st of the $1,500 a month he's going to pay on the new lease, the difference in value between that and the $1,000 a month he was going to pay to Leo during that time that he expected to pay under his lease with Leo. I think even if you don't know exactly what to do with that fact, it's nice if you can to just show the greater you understand some of the concepts behind when we award damages, why we award damages. Again, not an explicit remedies question where they're asking you to do the calculation. So if you have time, you could run through those 4 damages requirements: reasonably certain, causal, foreseeable, unavoidable. I don't think you have to. But if you could just show some of the arguments that Leo or Tuan might advance as to why or why not Tuan can get these damages, I think that can't hurt you. So I would say Tuan will probably argue that these are reasonably certain. It's $500 a month for 9.5 years. He's going to say they're causal. They're caused by Leo's partial actual eviction of him. They're foreseeable. It's foreseeable that if Leo, evicts him, he's going to need somewhere else to store his stuff. And he's going to say it's unavoidable because he needed somewhere to put his stuff, and that the $1,500 a month is that reasonable mitigation amount. He'll point to that almost identical warehouse from Bruno to say the fair market value is $1,500. It's a reasonable amount for me to pay. I think Leo will say, okay, yeah, they're reasonably certain, but I think Leo will say, look, you chose to terminate. Like, yes, termination is a remedy for you for partial actual eviction, but that was your choice. And once you terminated, that's on you what you do after that. He'll say, maybe this wasn't foreseeable, wasn't unavoidable because you had other options. You could have stayed and reduced your rent by 25%. You could have just asked me to move my stuff. You could have, sued for ejectment, in a trespass action. So I think Leo will make those arguments. And again, I don't think it's that important how you come out, but if you just, briefly show the grader that you thought about it for a second and, come up with some arguments, I think that's enough. So that's what I would talk about there. And then I think that I'm done finally talking about what claims Tuan would assert against Leo. So then I'm going to move on to question 2. What claims may Tuan assert against Annika? I'm going to say from January 1st to January 31st, nothing. I'm going to do the same thing. I'm going to break it into the different time periods because it's just easier for me to wrap my brain around, because there's kind of mad chaos in this essay. So January 1st to January 31st, I'm going to say he has no reasonable claim against Annika because she's lawfully there pursuant to her lease. She's done nothing wrong. From February 1st until May 31st, I'm going to say trespass. It's Tuan's property now. He has the lease. What's Annika doing? She's trespassing. And for damages for that, I would say, loss of use. So I'd say they're going to maybe have an argument there. And I would only get into this if I had extra time, because again, they didn't ask specifically about remedies and damages calculations, but they did give me numbers. So if I see it and I have time, I will talk about this. If not, do not worry. But I would say she's going to argue that the loss of use is the $1,000 a month, which is what he was going to pay for that property. So she's going to argue that's what the fair market value of that property was. He is going to argue probably that the fair market value is $1,500 a month because of this, almost identical warehouse he got from Bruno for that amount. So he's going to say to her, my loss of use of this property from February 1st to May 31st is $1,500 a month. That's what you owe me. And she's going to say, no, it's $1,000. And then the other thing I'm going to say is she's also going to raise the defense of consent, because he didn't do anything. When he returned there on February 1st, Annika told Tuan she was not leaving. And then it's like, oh, when he visited the warehouse on June 1st, it doesn't look like he did anything to say no or to object. And so I'm going to say she's going to argue implied consent, and that makes the trespass not trespass anymore. That's what I would do with that. I don't think I would say anything else about question 2. Then I'm going to move on to the third question. What counterclaims, if any, may Leo reasonably assert against Tuan? So for that, I'm still going to go through those same 3 time periods we've been talking about: January 1st to 31st, February 1st to May 31st, and then moving forward after June 1st. And what counterclaims? I'm going to say Leo is going to get mad at Tuan for not paying rent. He is going to say you breached your duty to pay rent. And for that first time period of January 1st to January 31st, I'm going to say Tuan didn't breach that. First of all, if we're modern, where tenant's duty to pay rent is dependent on landlord fulfilling his duties, then Tuan definitely owes nothing, because landlord very clearly breached his duty to deliver the premises. And then I'm going to say, even if we're in a jurisdiction where common law, those duties are independent, so that Tuan would have to keep paying, even if landlord didn't comply with his duties, and then Tuan would have to sue separately. I would say that that usually didn't include the duty to deliver possession anyway. Tuan would still be excused from having to pay rent if he never got possession in the first place. So Tuan's not liable for that first month, right? Leo's going to lose for anything he's asking for that first month. And I know they're not asking about remedies. They're not explicitly saying what will the outcome be. They just say what claims can he assert, but then they say discuss. If I see it, this is what I'm going to discuss, because it's, I see facts, and if I know rules, I'm going to do it. If not, I'm not going to worry about it. I'm just going to, do what I see. And then what's going to happen from February 1st to May 31st, when Leo says, hey, Tuan, you were supposed to be paying me rent. You owe me rent for that time. I'm going to bring up that dependent versus independent thing again. I'm going to say, if the duties were independent, then yeah, Tuan should have been paying rent, but then he'd be able to be suing for damages anyway for this breach of covenant of quiet enjoyment. So you kind of get to the same place. And then if their duties were dependent, Tuan was excused from complying with this duty at all. And then starting on June 1st, when Leo says you were supposed to be paying me rent starting on June 1st, Tuan is going to say, actually you evicted me, right? Partial actual eviction, breach of the covenant of quiet enjoyment. So I terminated. And that's where we get into that discussion where maybe Leo's going to say, well, you didn't properly terminate because it wasn't written. And Leo's going to say you abandoned. It was improper abandonment. If the court finds that his termination was proper, right, either informed means it was written or it was allowed to be oral, then Leo loses here too, and Tuan is done as of June 1st. If instead the court says, oh yeah, Leo, you're right, that should have been written and maybe it was oral, so it was improper termination, then they're going to have this argument about abandonment. And Leo's going to say, you abandoned, I didn't accept your surrender, I was only reletting on your behalf, so you owe me the difference in value between what Juanita gave me, the 500, and what I was supposed to be getting from you, what I expected, which was the 1,000. And I think there's a couple issues there. If I have time, I'll bring up, and if not, who cares? Maybe I've already run out of time at this point. If I see it, because they've given me these numbers, I would argue that maybe Leo can't get that whole difference in value. I would say Tuan is going to say, excuse me, this property was actually worth 1,500. At a minimum, you were renting it to me for 1,000. Why did you sign a 10-year lease for 500? That's not reasonable mitigation, especially because it was shortly after you were able to rent it so quickly. Tuan's going to say you should have waited until you could find a tenant that could rent it for closer to the amount that I was going to pay, or closer to the fair market value of 1,500. And Leo's going to counter and be like, look, I did the best I could, because you just like up and left, and it's hard to find a tenant, and so you owe me. And I don't know how the court would come out on that, but if I see it, I'm going to talk about that a little bit quickly. And that's what I would do. And then I would say it's a 10-year lease starting July 1st. It should have been a 9.5-year lease, the same way that this second Tuan's later 9.5-year lease was. I think that Tuan should only be on the hook for that $500 to the extent he has to pay it for the 9.5 years, not the full 10. And then Leo would counter and be like, that's the only way I could get a tenant. But I still think that Tuan would only be on the hook for the 9.5 years. And And that's, again, if the termination is deemed improper and Leo can get away with saying, oh, I was reletting on Tuan's behalf. Otherwise, if we say that the termination was improper and Leo, by reletting the property without telling Tuan that it was on his behalf, he was just accepting the surrender, then Tuan's not on the hook for anything. That's what I would do with that. And then, maybe I would argue, if I have extra time, which I don't anymore, but I would say, maybe Leo's also going to say you breached the contract by improperly terminating, right? Maybe he's going to, instead of saying you didn't terminate at all, it was abandonment, he's going to say you improperly terminated. And he's going to lose on that because Tuan was totally allowed to terminate, because a remedy for partial actual eviction is termination. And that's all I'm going to do. I don't need to talk about constructive eviction because this was all physical stuff. If for some reason I wound up talking about constructive because I was didn't quite see that it was actual, what I would be I'm not going to spend time on that because that's not applicable and I don't want to waste any more of your time. But I would point out that Tuan never gave any notice to Leo. That's like something that's jumping out at me in this fact pattern, right? Like Tuan never told Leo, like, wait a minute, I can't possess it because Annika's here. And then, he could have said that on January 1st. He could have said that on February 1st. He never gave any notice to Leo to allow him to fix the problems. He just left. And then, on June 1st, he just terminated. So again, I wouldn't talk about constructive eviction because I don't think it's at issue here. I think this is just actual eviction. But to the extent you found yourself IRAC in constructive eviction, if you wound up down that path, that's the element that I would say is problematic for Tuan. That's what I would do with this essay. I think it's very chaotic. I'm sorry if you had to experience it. I think it's a mess. But if you can break it up, the way that I see, like, to make it most manageable for me is break it up into act by act. The month of January, and then when things change, right after Annika's lease runs out from February to May, and then when things change again on June 1st when Annika's gone, and now it's just Leo doing his trespassy partial actual eviction. Hopefully that was helpful, and hopefully we all survived. Okay.